Now please give your attention to Mr. Fortunato for his closing argument on behalf of the city of Tumwater. Mr. Fortunato.
Good afternoon, everyone. I appreciate your attention throughout this trial. You've heard a lot of information today, but I want to remind you that you're here to determine if Mr. Farley is guilty of assault in the 4th degree. The city has met its burden of proving that Mr. Jeremiah Farley assaulted Mr. Randy Rainey on July 20th, 2023 in the city of Tumwater, Washington. All the legal information I share with you will be in your jury instructions, and be sure to refer to these instructions for guidance for any questions on the law. If at any point the city or defense misstates the law, follow as written in the instructions. Do not apply laws that are not in the instructions. With that, please keep in mind that to be found guilty of assault in the 4th degree, the prosecution must prove 2 things: that the defendant assaulted someone and that it occurred in the jurisdiction. If you could turn to jury instruction number 8, you could follow along with me. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Based on this, the city has met its burden of proving Mr. Farley's guilt beyond a reasonable doubt. Through testimony of Officer Peter Navarro, Mr. Sam Kirkley, and Mr. Randy Rainey, as well as the video that was recorded by Mr. Farley, the city has proven the following. Mr. Farley entered the Department of Social and Health Services office in Tumwater, Washington, and began recording on his devices. He was advised that he was not allowed to record people in the waiting area. Mr. Farley disregarded requests to stop recording and continued into the waiting area of the office, all the while continuing to record. Mr. Rainey motioned toward Mr. Farley's recording device in an attempt to prevent him from continuing to record the DSHS patrons. In jury selection, you all uniformly agreed that confidentiality and security were 2 of the main valid reasons for forbidding recording in government administrative offices. Here, DSHS patrons certainly share sensitive and personal information. Mr. Rainey intervened in this situation to ensure that these patrons' confidentiality and privacy, as well as their safety, were protected. Mr. Farley twice struck Mr. Rainey and aggressively shoved him in an attempt to continue his recording. This recording issue provides context, but again, I want to remind you that you are here to determine if Mr. Farley is guilty of assault in the 4th degree. This requires 2 elements: that Mr. Farley assaulted someone and that it occurred in the city of Tumwater. Mr. Farley does not contest that the acts occurred in the city of Tumwater, the county of Thurston, and the state of Washington. The city has proven beyond a reasonable doubt that Mr. Farley intentionally struck or touched Mr. Rainey in a manner that is offensive. Mr. Farley twice hit Mr. Rainey in the face and also shoved him aggressively. Undeniably, this touching and striking would offend an ordinary person. Mr. Farley assaulted Mr. Rainey. Once again, I urge you, consider the testimony that's been presented to you here today throughout this entire trial. Consult the published exhibits that will be available to you in the deliberation room. And most importantly, refer to and follow the jury instructions strictly when it comes to the law. Because the city has met its burden in establishing that Mr. Farley assaulted Mr. Rainey in Tumwater, Washington, Mr. Farley is guilty of assault in the 4th degree. The city requests that you return a guilty verdict. Thank you.
Members of the jury, would you please give your attention to Ms. Rowe for her closing argument on behalf of Mr. Farley?
Thank you, Your Honor. We are here to decide if Mr. Farley assaulted Security Officer Rainey. My closing is going to walk through the evidence that was presented today. The state's first witness was Officer Peter Navarro. Officer Navarro indicated that he has been a law enforcement officer since 2018, that he received extensive training to become a police officer, and this included assault training, and he indicated that he has executed at least hundreds of investigations. What I do find interesting is that when asked, Officer Navarro indicated that he had never arrested individuals for videotaping, video recording at all. We are not disputing that the incident occurred on July 20th. We are not disputing that the incident occurred at the DSHS office. But Mr. Farley's versions of the event are much different than the state's. It was very important for the state to ask each of its three witnesses to describe the layout of the DSHS office. That's very important because where Mr. Farley entered into the building is very important. Mr. Farley didn't enter the building on the entrance that's closest to the parking lot. Mr. Farley did not enter the building by the entrance that's closest to the security guard corner. Mr. Farley did not enter the building in the entrance where a notice was posted regarding the use of video recording. Mr. Farley attempted to enter into the DSHS office on the far entrance. That's very important to take note of. Going back to Officer Navarro's testimony, he indicated that the east entrance where Mr. Farley entered consists of a long public hallway where there are bulletin boards placed throughout the hallway. That at the end of this long hallway, there are double doors on the left side of the hallway that are the entrance from the hallway into the DSHS office. We also know from everyone's testimony that Officer Navarro was not present and did not witness the incident himself. In fact, Officer Navarro and other officers responded to a dispatched call. Officer Navarro indicates that he wasn't even the officer who took witness statements, the witness statements from the witnesses inside the DSHS office, but that he, in his role that day, was to take Mr. Farley's version of the story. When asked, Officer Navarro indicated that Mr. Farley's demeanor was polite, was respectful, was conversational, and that he was straightforward in his answers. He did note, however, when asked about his facial expressions, that Mr. Farley appeared to be concerned. Then we heard Officer Navarro testify that when he contacted Mr. Farley also recorded their communication. When asked whether he had any concerns over being recorded himself, he indicated he had no concerns. Officer Navarro asked Mr. Farley what was his purpose of being there, and Mr. Farley gave him a straightforward answer, told him that he was there to record the normal business practices and the daily activities. He indicated, and I believe Detective Officer Navarro indicated, that Mr. Farley said he was a freelancer reporter of public buildings. When asked whether or not that concerned Officer Navarro, he said he had no concerns over that at all. When asked, Officer Navarro indicated that the hallway, or Officer Navarro testified that the hallway leading to the DSH office, DSHS, that's a little bit of a tongue twister, that Mr. Farley was in public space. When asked, Officer Navarro also testified that the lobby portion of the DSHS office is also public space. Officer Navarro indicated that Mr. Farley relayed to him that his belief that he had the right to record in public spaces. He told Officer Navarro that security guard Rainey got into his personal space, that he backed up in an effort to de-escalate the situation, that there was discussion had that led into the touching altercation. Officer Navarro indicated his understanding that the DSHS supervisor was called, and he indicated that what Mr. Farley represented to him appeared to be quite a bit of chest bumping and shoving back and forth, but that all of that contact occurred basically in the east entrance doorway before Mr. Farley had even gotten into the lobby. When asked, Officer Navarro indicated that Mr. Farley did not resist and Officer Navarro taking his devices as they could be used for evidence. Never at any time did Officer Navarro indicate that there was a need to subdue or restrain Mr. Farley. He wasn't attempting to get away. He wasn't attempting to leave. In fact, by his testimony, it appeared that Mr. Farley went out once he saw law enforcement had arrived. It was Officer Navarro's duty under his job as a law enforcement officer to record Mr. Farley's version of events that day. When asked whether or not Mr. Farley whether or not Mr. Farley denied touching Security Officer Rainey at all, the response Officer Navarro said was that Mr. Farley told him he did what he needed to do to protect himself. Officer Navarro also indicated that outside of his taking Mr. Farley's statement, he did not interview any of the other witnesses. I want to go back to Officer Navarro's explanation of the layout of the land, so to speak. Officer Navarro indicates that to his knowledge, there are signs posted inside the lobby, in the security area, and on the middle retaining wall regarding the use of video recording. When I showed the pictures of the layout of the land, so to speak, officer identified 2 areas where this notice was located, where these notices were located. These notices were located on the middle retaining wall, far away from the entrance that Mr. Farley entered in. He indicated that actually the communication started in the hallway. The altercation took place just inside of the door, and that the notices regarding recording were in the middle of the room in the lobby. When asked, Officer Navarro assumed that or believed that DSHS does have its own recording cameras. He also indicated he did not personally view any camera footage from DSHS regarding the incident. I find that very important to stress because there may have been other video evidence out there that could have shown a clearer picture of the incident.
Your Honor,
But we are left
I have
with
to
this
object.
recording.
That
I'm just,
includes
I'm
facts,
just,
not
hang on a second.
evidence.
I'm going to remind the jury that the lawyer's remark statements are not evidence. The evidence is contained in testimony. The law is my instructions. With that, Ms. Rowe, you may continue.
Officer Navarro indicated that Officer Security Guard Rainey asked Mr. Farley to stop recording in the hallway. That was not restrictable behavior. We also noted, and Officer Navarro testified, that Mr. Farley was not cited nor arrested for recording. In fact, that's when he indicated that he has never arrested anyone for recording in a public space. He also indicated that no patrons from inside the DSHS office came out and relayed any privacy concerns that they may have had. He made a point to testify that it did not appear Mr. Farley was attempting to invade investigation. And lastly, according to Officer Navarro, Mr. Farley had no prior knowledge of any rule of DSHS. I next want to bring your attention to the testimony of Mr. Kirkley, who was a witness. Mr. Kirkley testified what business he had at the DSHS office that day. And he also testified that he personally did not see any signs inside the DSHS office regarding recording. He again described the layout of the DSH office, and when shown the pictures of the layout of the land, he confirmed that that's what the inside of the law office looks like. He also testified that this incident and basically the hullabaloo that began started in the public corridor. They weren't even in the office yet. He indicated that he personally did not see them come in, but heard a scuffle, and he knew the topic that was being discussed was recording. When asked if any employee of DSHS came out to advise Mr. Farley of any recording rule, he did not recollect any employee of DSHS notifying Mr. Farley of this. He indicated that he saw security guard Rainey basically lunge for Mr. Farley's recording device, not once, not twice, but 3 times. He heard Officer Rainey referencing not recording these people without asking their permission. When Officer Rainey lunged for Mr. Farley's recording device, he heard Mr. Farley tell him, "Don't touch me. Get off me. Don't touch my phone." He indicates that Mr. Farley was holding his cell phone in his hand. And he indicated that when security guard Rainey was attempting to go towards his recording about device, that Mr. Farley did everything he could to keep his recording device out of the reach of Mr. Rainey. When asked, he indicated that it did appear that security guard Rainey was invading his personal bubble, his personal space. He may have testified that he believed there was good reason for that, but that's what he testified to. I find it also very interesting that his testimony was that Officer Rainey was calm, was not yelling, wasn't threatening. I believe that the video that was shown depicts otherwise. There was a lot of loud noises, scuffling that we heard on that video. But again, Mr. Kirkley indicated that the communication between Mr. Farley and the security guard was extremely close in proximity. He indicated that Mr. Farley responded in a defiant and agitated manner, stating what he believed to be his rights. Mr. Kirkley then went on to describe what he perceived was Mr. Farley balling up his fist and actually punching security guard Rainey. But I would argue that the video recording shows otherwise. Had Mr. Farley had the chance to step away, ball a fist, Mr. Farley, and punch him, that did not happen. He didn't have that chance. Security guard Rainey was all in his face, all up in his personal bubble. And what he did was to push him back multiple times. We heard from Mr. Kirkley that this officer went for the phone 3 times. But when asked how hard his perception of the hand strike was, it was about 50% power. He believed the security officer never broke training protocol, but that was just his personal belief. He indicated that he heard Mr. Farley yell, "Don't touch me, don't take my stuff." He assumed that Mr. Farley had no other business there than to cause problems. But we know what assuming can do for an individual. He indicated that throughout this process, Mr. Farley was continuing to record this incident. He noted the tenure of the patrons in the lobby. He noted that everybody was upset and there was a big hullabaloo, which is understandable when an incident such as this happens. He indicated that during this incident, or shortly thereafter, that administrative personnel of Dshs came into the lobby and worked to de-escalate the situation. He also supported Officer Navarro's testimony that there were patrons who went to law enforcement to give statements. Unfortunately for us, we only heard from one of those witnesses today, even though there were multiple witness statements given. We don't know if there were witness statements that corroborated or refuted Officer Rainey's version of the story. We do know that the witness that the state chose to bring forward supported their position. I also want to point you to not the one time and not to 2 times, but to the 3 times that this witness testified that he didn't think the the security guard should have tried to take Mr. Farley's phone. If I could, Your Honor, please. I need to take a sip of water. He reiterated that 3 times. He indicated that this whole thing didn't have to happen. I would argue that he is absolutely right. This whole incident didn't have to happen. Unfortunately for Mr. Farley, it did. And that's why we're here. He indicated on cross-examination that the security officer appeared to be trying to stop Mr. Farley from entering into the office at all. Those were not part of his job duties. He was not assigned the duty of accepting or refuting persons who want to come to the office because they have business to attend to. Additionally, Mr. Farley does not have to tell other persons what business he was there for. He is a grown individual who did not have to answer that question. So even though he testified that he didn't have any knowledge of Mr. Farley's business, it does not mean that Mr. Farley did not have business there. I then want to bring your attention to the testimony of security guard Rainey himself. He indicates that he's been a security guard for 12 years and that he has worked at Dshs for 3 years. He also confirmed the layout of the land that the 2 prior witnesses had described. And he indicates in his own testimony that the lobby is a public space. And when asked, his specific words were, "You can record in the lobby." He was asked this again, in fact, by the state. And once again, he reiterated, recording is allowed in the lobby. It's not allowed behind that half-wall barrier, but it is allowed in the lobby. On the video, you will see Officer Rainey lying to Mr. Farley. Mr. Farley asked him, "Is this a public space?" And he said, "No, this is not a public space." Now, he corrected that lie on the stand today, but you will see.
Your Honor.
I'm gonna sustain the objection. And yeah, I'll sustain the objection.
The video will show that security officer Rainey informed Mr. Farley that that was not a public space. Today, he testified that it was. Then we started talking about where the notices were located in the office itself. And security officer Rainey again pointed to the signs that were located in the middle of the lobby, on the wall and the pillar, and on the far side in the security guard corner, which was not the side that Mr. Farley entered the building on. That's very important. When asked, once again, Officer Rainey indicates that Mr. Farley was not made aware of the rule at first. He testified the incident occurred in the lobby and at the threshold. He indicated that he ordered Mr. Farley to leave the building. Once again, that was outside of his job duties. He did not have the duty to order a private citizen to leave a public building where that private citizen
Objection, Your
came
Honor. That's
to
not
conduct.
Sustained. You need to move on then as well.
Okay. He simply ordered him to leave the building. And this was before he had even crossed the threshold. He indicates that he was struck on the left cheek. However, we have seen no pictures of any injuries that were sustained by Security Officer Rainey. He indicates that he believed he was talking to Mr. Farley in a quiet manner. I would argue otherwise. He indicated that he stepped back when asked by Mr. Farley, but the video will show otherwise. When asked, Security Officer Rainey indicated that it is not part of his job description to attempt to exert any control over another person's personal property. In fact, when asked what was the procedure that he should have been followed, he indicates that he would call his supervisor or call law enforcement. Those are where his duties stopped and where the duties of law enforcement kick in. Mr. Farley was there to conduct business in a public space at a public agency, and he wasn't even given the opportunity to record in a public space. When asked why he didn't inform Mr. Farley what sections of the office, the inside office, Mr. Farley was able to record and which sections were the actual restricted areas, he said on 2 or 3 occasions, it didn't come up. Well, it should have come up. That was his job description. His job was to inform the public where they could and could not record video. He did not do his job. He jumped to conclusion. He jumped to act before he had the authority to. When we asked him whether he saw Mr. Farley recording specific individuals, he indicated no. He didn't see what Mr. Farley was recording. Instead, he jumped to attention. When asked specifically whether his job description includes touching another individual, his response was, he is not allowed to touch someone unless he's being attacked. He touched Mr. Farley first. And at that time, he was not being attacked. In fact, we would argue that security guard Rainey was never attacked. He was pushed out of Mr. Farley's personal space. I want to also reference the questions that were discussed in jury selection. When asked whether or not how many persons would stop recording just upon demand, several of the jury pool indicated that that would not be enough to make them stop, that they'd need more. In fact, I believe it was represented that security guards don't always get it right. They are not versed in the law and may not be accurate in the law. I lastly want to bring your attention to the jury instruction that focuses on what an assault is. Jury instruction number 8 begins by saying, an assault is an intentional touching. That was done by Security Officer Rainey. An assault is the intentional touching that is harmful or offensive. We heard testimony from Mr. Farley that the initial touching and the continued aggression.
Your Honor, may we have a sidebar?
I'm going to sustain the objection. You could move on, and then we'll go from there. And we're not going to, we'll just allow you to continue, Ms. Rowe.
Thank you. Security Officer Rainey intentionally touched Mr. Farley.
Objection, Your Honor. Again, same purpose here.
Okay, members of the jury, we're going to have you go back into the jury room. And then this should be pretty short. Mr. Fortunato?
Your Honor, this is precisely what was mentioned immediately prior to closing arguments. This is going down the line of speaking into, or what our speaking objection was, that this is the defense of self-defense. This is exactly what Ms. Rowe is attempting to do here. She's attempting to backdoor this
No.
self-defense argument. She is attempting to say that Mr. Rainey was instead the person who assaulted Mr. Farley, and that is going down the line, of course, into justifying his pushing of Mr. Farley, or of Mr. Rainey, rather.
Ms. Rowe?
Your Honor, I disagree with that analysis. I am simply reading the jury instruction.
Okay.
And
No, you're not. You're saying that, I thought I heard you say Mr. Rainey is assaulting Mr. Farley. Intentionally touching.
I said he intentionally touched Mr. Farley.
Yes, that's what you said. That's not reading the jury instruction. Okay, the jury instruction is the definition of an assault. You're kind of citing what would be a to convict instruction if Mr. Rainey were accused of assault and on trial here, which he is not.
Okay.
And so the issue here is whether or not in this trial is whether Mr. Farley assaulted Mr. Rainey. That's it. And so I would confine your arguments to that issue. So as we discussed, the defense of others is not before the jury.
Right.
Can't argue that. And so let's assume for the moment that even if Mr. Rainey did assault, that doesn't have anything to do whether or not Mr. Farley assaulted Mr. Rainey. So avoid that argument. We're going to bring the jury back in. You know, Mr. Rainey's not on trial here. And so it's not even an issue as to whether or not he assaulted Mr. Farley. And frankly, the evidence doesn't support that based on, if you look at the video combined with the other testimony. And again, that's not even an issue for this trial. The issue is whether or not Mr. Farley assaulted Mr. Rainey. That's it. And so we can, do you understand that?
I understand, Your Honor.
Great. You can bring the jury back in and you can continue. And Ms. Rowe, you may continue.
In conclusion, the state has to prove the elements of the crime. And it is your duty to find that the state has met its burden beyond a reasonable doubt. In this case, we would conclude that there is reason to doubt in this case. And if you conclude so, you will find Mr. Farley not guilty. Thank you.
Thank you, Ms. Rowe. Members of the jury, the state carries the burden of proof in these cases. And as such, they're entitled to a rebuttal argument. So for one last time, would you give your attention to Mr. Fortunato for his rebuttal on behalf of, I said state, I meant state, on behalf of the city.
Thank you, Your Honor. And I promise I will keep it very brief. I have three things to tell you. One, what myself, on behalf of the city of Tumwater, and Ms. Rowe say are not evidence. What we characterize things as is not evidence. Evidence is evidence, and you will be provided with exhibits when you deliberate. Number two, You are here to decide whether or not Mr. Farley assaulted Mr. Rainey. Not where Mr. Farley was in a hallway. Not whether Mr. Rainey was in Mr. Farley's personal space. And not whether Mr. Farley had sufficient notice of the DSHS's office policy regarding recording devices. And number 3, follow your jury instructions. Thank you.
So members of the jury, the 6 of you, with the exception of you, sir, in the maroon shirt, I think that is, you're the alternate. And so what's going to happen is that jurors number 1 through 6 are going to go back to the jury room to begin their deliberations. Juror number 7, you're still the alternate. You're still on call, so to speak. I have had the experience where juries begin to deliberate and then something happens, some emergency arises, someone has to leave. We have to call in the alternate and then you have to start all over. So even though you're going to get to leave in a minute, your job isn't over yet. I do want you to give your contact information to the clerk. And when then a verdict is reached, one way or the other, we'll contact you, let you know, and then all the instructions will be lifted at that time. But until then, until you hear from us, all the instructions will remain in place. So jurors number 1 through 6, you can go back to the jury room. Yes, sir.
Will the video be available to us in the deliberation?
Well, yes, it will be. If you wish, I'm going to have you go back there and begin your deliberations. If you wish to view it again, you can let the clerk know, and then we can, and then talk amongst yourselves. If you wish to view it again, you can be brought back in to view it again. Okay.
And Your Honor, the city would reiterate again that I believe it's appropriate for the jury to be able to review the video in the.
We're going to see what happens. If they ask for it, we'll probably just send it back there.
I understand, Your Honor. I just, thank you.
Your verdict in you, ma'am, juror number 2. Am I correct in assuming you're the presiding juror? I see you have the verdict in your hand. I'll have you fold it against itself there on the inside, and then you can go ahead and put the crease in there. You can hand that to the clerk. She'll bring it to me, and then I'll read it into the record, and you can be seated. City of Tumwater versus Jeremiah Shane Farley. The jury verdict reads as follows. We, the jury, find the defendant Jeremiah Shane Farley not guilty of the crime of assault in the 4th degree as charged in count 1. And juror number 1, is this your verdict?
Yes.
Is this a verdict of the jury? Is this your verdict? I'm sorry, ma'am, you need to answer out loud. Okay, and this the verdict of the jury? Is this your verdict?
Yes.
Is this the verdict of the jury?
Yes.
Is this your verdict, sir?
Yes.
And this is the verdict of the jury? And you, ma'am, in the back, this is your verdict? Is this the verdict of the jury? And then finally you, sir, this is your verdict?
Yes.
And this is the verdict of the jury?
Yes.
I now lift all my previous instructions. You're free to talk with whoever about this case with whoever you like. At the same time, you don't have to talk about it if you don't want to. I am going to send you back to the jury room, and then you can wait for a few minutes. I'll come back and excuse you formally in just a moment. There's a reason why they call this to practice a law, in the sense that attorneys always like to talk to jurors post-verdict, find out what resonated, what didn't. And then if you wouldn't mind waiting for a minute, I know the attorneys would like to speak with you for just a few moments, but given the amount of time that we've been here, you don't have to be here for very long. You've been here all day. It's been a long day for everybody. But for right now, you can go back to the jury room. And so I guess I'll enter an order that Mr. Farley remain released. All conditions have been lifted, and that'll be that. Do you folks wish to speak with the jury?
I would, Your Honor, if
Okay.
possible.
I probably will pop my head in also.
And Mr. Farley, you're free to go. Thank you, sir. You're welcome.